Hi, everybody. You're watching the virtual amicus, and I'm Jay Lodha. Well, who is an arbitrator? Who appoints an arbitrator? Under what circumstances can a mandate of an arbitrator be terminated? So, why do we need an arbitrator? So, suppose if there is an arbitration agreement and there is a specific arbitration clause that talks about, say, let's say a person X shall be the arbitrator, then why do we need to file a Section 11 application? So, to answer to some of these queries or questions that you have, or that continue to baffle you, we have with us Miss Shretima Bagri. Well, she has a prolific litigating career. She is someone who has skilled not only in real estate matters, but she has also has a diverse portfolio to boast of, where she has done civil, commercial litigation, insolvency proceedings. She has excelled in infrastructure and banking finance matters, securitizations, consumer protection. The list goes on and on. She initially started a career where she at Parasquad and Associate, where she worked at the position of a paralegal. Subsequently, she joined the chambers of Additional Advocate General Shri Rajesh Maheshi ji, and she worked there from January 2020, and she continues to work there. She also has an independent practice that ranges from hospitality, healthcare, manufacturing to banking, finance, etc. So thank you so much, Ms. Bagri, for taking out time from your busy schedule. And the stage is set, the floor is yours. Over to you.
Hello everyone, I'm Shretima Bagri, and today I would like to speak upon Section 11 of the Act of the Arbitration and Conciliation Act, which provides the parties liberty to devise their own procedure to appoint arbitrator, but with some or the other limitations involved. Now, starting with this Act, I would want to focus and correlate it with Section 21 of the Act. The most important part in this aspect is that Section 21 is a mandatory procedure, but is very different from what Section 11 otherwise provides. The appointment procedure as defined in Section 11 of the Act is not to be confused with the mandatory procedure, as I said. The purpose of Section 11, subclause 6 of the Act, without the notice under the Section 21 of the Act, provides that a party seeking a reference of dispute to the arbitration will be unable to demonstrate that there was a failure by one party to adhere to the procedure and accede to the request for the appointment of an arbitrator. The trigger for court's jurisdiction under Section 11 of the Act in such failure by one party is triggered by the response of Section 21. Now, most important part as to what are the circumstances under which courts step in under Section 11 of the Act. Now, the parties to an arbitration are free to agree to whatever procedure, whether it is an EPC agreement, whether it is a service agreement, whether it is an infrastructure or any kind of agreement. All the procedure that is involved in Section 11 can be previously agreed upon. But in the circumstances that the procedure is not followed by one party or the other, or there is no proper agreement in what scenario. For example, there is just an arbitrability clause, but it is not provided as to who would be the arbitrators in the arbitration proceeding. So in such situation, the courts usually step in, and application under Section 11, subclause 6 is being filed either at the Supreme Court, where international arbitration are involved, and in respective territorial jurisdiction of High Court, where domestic arbitration is involved. Now, moving on to what has been from the very start, the different judicial interpretation which has been given to various subsections of Section 11. In this respect, actually, I would like to start with the case of Sundaram Finance versus NEPC India Limited. Now, one of the basic nemesis which was looked upon in this was whether the order which has been passed by the High Court or the Supreme Court under Section 11 of the Act, would it be an administrative order or would it be a judicial order? Moving on with that, in the case of Sundaram Finance versus NEPC India, it was held that under the 1996 Act of Appointment, the order which is passed under Section 11 would be an adjudicating administrative order. It will not amount to a judicial order. This view was further confirmed by the Supreme Court in a 3-judge bench in Konkan Railway Corporation versus Rani Construction, and this further affirmed by a 5-judge bench as well in the Supreme Court. In conclusion, it was said that we hold that the order of Chief Justice or as designate under Section 11 nomination of arbitrator is not an adjudicating order, not a judicial order, and the Chief Justice or his designate is not a tribunal. Such an order cannot therefore be challenged under Article 136 of the Constitution through the viable of special leave petition. Now, this was the initial stage under which this was looked upon, but moving on to the case of Patel Engineering and another, this case provided, what can we say, a final position whether the order which has been passed under Section 11 would amount to a judicial order or not. This case completely overturned the position for what it had been provided before the applicability of Section 11. According to this, the order which has been passed by under Section 11 would amount to a judicial order and not an order of administrative nature. It also threw a light as to what factors would be looked upon by the High Court once Section 11 arbitration is being submitted. Initially, it would look upon the jurisdiction to entertain the request, the existence of a valid arbitration agreement, the existence of a live claim, and the existence of the condition for exercise of power and qualification of the arbitrator. Now, this is the final position, and it is important to say that even when we file an application under Section 11, even today the court only looks upon these 5 arenas that I have just mentioned as to whether there is a valid arbitration agreement, whether if the arbitration agreement is itself is in dispute, then probably the court will not move further. And then, of course, the dispute. There should be a valid dispute which has to be agreed by both the parties. Now, moving on with further judicial evolution, which came on in Section 11. Now, I would like to, at this point of time, read Section 11 with Section 12.5, 12 subclause 5, which lays down that notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in the schedule shall be ineligible to be appointed as an arbitrator. Now, this gives an exception as to who cannot be arbitrator in any case. And at this point of time, it is very important that I read the first entry of the 7th schedule, which is that the arbitrator is an employee, consultant, advisor, or has any other past or present business relationship with the parties. This throws a very general light because obviously if a person who has been itself associated somehow with the institution cannot probably give a partial service as an arbitrator. So in this respect, it is very important that we go through these arena of cases, starting with TRF Limited versus Energo Engineering Projects. Now, in this case, the question which arose was whether the appointment of an arbitrator made by the managing director of the respondent authority was a valid one or not. As I said, that if a person itself is associated with the institution itself, the question of partiality would definitely arise at one point of time. But the difference which lies in this case is that the person himself is not the arbitrator, but the power of appointing an arbitrator would lie to the respondent authority itself. Now, in this case, the Supreme Court held that once the arbitrator has become ineligible by operation of law, for example, in this case, the respondent managing director would be inapplicable to pursue an arbitration matter. Similarly, if a person who was ineligible at first place to pursue a matter as an arbitrator cannot appoint another person as arbitrator because that would question the biasness of the matter. He cannot nominate another person as an arbitrator. The arbitrator becomes ineligible as per prescription contained in Section 12.5 of the Act. It is inconceivable in law that person who is statutorily ineligible can nominate a person. This view was further propounded in Perkins Eastman Architects DPC versus HRCC as well. This case actually went a a step further in clearing the issues if it states that the person who has become ineligible appointed as an arbitrator would and cannot be in a position to appoint a impartial person. As I just said, the person interested in the outcome of an arbitration is also ineligible to be appointed as an arbitrator and should not be nominated as the same. Now, this is regarding the people who cannot be associated as an arbitrator in a proceeding because they themselves are interested. The next case, which is the Central Organization for Railway Electrification, shows a different scenario because in this case, parties agreed upon a panel of retired officers. Now the question arose, as they are the retired officers, can they be allowed to perform their services as arbitrators? Would their interest will not be harmed by the proceeding itself? Now, in this case, the court gave a very clear view that a person once retired, once not associated with the organization itself, or does not have any business relationship with the organization itself. Now, that person has the right to become an arbitrator, and there is no bar of the same. So, I guess keeping in mind all these scenarios, we can say that there are basically three scenarios that we can agree upon. First of all, that appointment of a sole arbitrator needs to be done with a mutual consent, and explicit clause in the agreement needs to be mentioned when it comes to sole arbitrator. Second, when approaching the High Court or Supreme Court to appoint a sole arbitrator, in case there is a dispute between the parties, again, another person who has been associated with the organization cannot be appointed. And otherwise, an option to choose from the panels of arbitrators, which tantamounts to the power given to the other party to nominate the arbitrator, can be provided to the parties. Now, moving on, I would like to talk about amendment of 2019, which although hasn't been notified yet, but has a very drastic difference, a drastic change, I would say, and shed a lot of clarity on section 11 as well. Now, amendment empowers the court to designate arbitral institutions for the purpose of appointment of arbitrator. So it is like a delegation that the courts are conferring regarding the power of appointment of arbitrator, which it had been limited till then. Such arbitral institution graded by arbitral councils would be allowed to appoint arbitrators, and the Chief Justice of the concerned High Court, or in case of international arbitrations, Supreme Court, would maintain a panel of arbitrators for discharging the functions and duties of the arbitral institutions. In the absence of appointment of an arbitrator or failure of such procedure under the agreement, the appointment will be made by the arbitral institution designated by Supreme Court or the High Court, as the case may be. The application for appointment of an arbitrator will be disposed of by the arbitral institution within a period of 30 days from the date of service of the notice on the opposite party. Now, it is also very important because if a delegation has been made, then obviously it has to be regulated. And the amendment has ensured that a delegation has been done in a very time-bound manner. And that is why this period of 30 days has been provided. So I guess with this presentation, what I'm trying to convey is that section 11, once when it was enacted in 1996, can be said was a very naive provision, but through its judicial evolution, it has taken another character on its own regarding its applicability.
Thank you so much, Ms. Bagri, for this lovely, pinpoint, precise, and concise presentation. I am sure that viewers are going to immensely benefit from this presentation. So there's one big advantage that a PPT has. So whatever the speaker is trying to present, it gets permanently registered. It catches hold of attention of everyone. It is hard to lose focus. And it's easier to talk, but it's so hard to put in so much of effort and to translate them into presentations that you've done. That too on a working day. So I'm really very grateful for whatever you've done, all the effort that you've put in. And thank you so much, everybody. Once again, keep pouring all your love, keep pouring all your blessings. And one more thing that I wish to say, our email is mentioned in the channel. So feel free to write to us in case if you have any queries that remain unanswered. We would be more than happy to forward your queries as it is to the speaker who has conducted that session, and so that you get the best possible advice. And you don't even end up a lot of time, to finding out solutions to problems that we can otherwise cater to. So thank you so much, Ms. Bagri, once again. And thank you so much, everybody. Please like, share, and subscribe my channel. And please stay home. Please stay indoors. Please continue to be indoors as much as you can for as long as you can. And keep watching the Virtual Amicus. Stay tuned. Next episode is on its way. Thank you so much. Thank you so much, Ms. Bhatt. Thank you.